You're here to pass your real estate exam. So we're reviewing national and Texas state questions. So remember to participate and comment by typing in the question number and the letter answer. If you're watching the replay, hey, you can fast forward at any point. Anyone that's watching on Facebook, since we are live using StreamYard, please go to streamyard.com/Facebook and give StreamYard permission to see your name on here, just like you see Agent Prep on top, instead of seeing just Facebook user. So you're here to pass, right? So let's get you to pass by practicing more and more questions. And remember that whenever you do not pass your exam, okay, your test, you don't fail. I post a comment on our Agent Prep Facebook group, private group, about we're not a failure when we don't pass. Just lets us know that we've got to study more and the right topics, or take a different approach to studying, to preparing for the exam. You know, it does take discipline, commitment, scheduled hours, and total focus and rest periods, and understanding the material, not just memorizing. Okay, so by learning the material, you might have more fun than just trying to memorize. Okay, because that memorizing, you know, you'll forget it as soon as possible. And we remember the beginning and end of every 20 minutes that we study, and that's by Jim Frick on YouTube. Okay, he talks about how our mind works. So when you study for long periods of time, you're going to probably forget everything that's in the middle except for the beginning and the end. So they recommend highly to take quick breaks every 20 minutes. All right, so we're continuing with, this is national questions, number 3.26. What portion of a section is 10 acres? What portion of a section is 10 acres? So remember the drawing I showed you. Let me see if I still have it up. I think I do. So this is the township, okay? And it has 36 sections. Each section, okay, gets divided like you see on this parcel here. And it gets divided like this. So it gets divided in quarters and keeps, again, quarters, okay, and either half or 1/2 this way, north and south, west and east. So what is a 10 acres? Type your answer in the chat. Challenging one, huh? So the answer here is 164, number D, letter D, 326D. Hi, Melanie. Hi, Cindy. Hi, Kathleen. So again, let me pull up that. Okay, because each of these townships is, let me see, where's the good description of this? Oh, that's not what I wanted to see. Okay, because one of these squares, right, is 6 miles by 6 miles. We did that on Monday. And a whole township, okay, has 640 acres. So on this here, oh, well, it won't let me, let's see if I can enlarge it. No, it didn't do that. So I'm trying to show you each of these sections is equal to 640 acres. Okay, you can Google it and be able to see what it's equal. So it's saying if it's 640 acres and you're looking at what 10 acres is, then you divide what? 640 divided by 10, or 10 over 640. So you have, and you narrow it down, reduce that down to 1 over 64, right? So, well, everyone, let's see. I'm so excited I got to join your live. Thank you so much. You're very welcome. So I'm so glad, I'm so excited you're here. Okay. So you've got 640 acres in a whole township. And that is, I'm sorry, in a section. Okay. So a township has 36 sections. Each section is 1 foot by 1 foot. 1 foot by 1 foot. Oh my gosh, 1 mile, 1 mile. So 1 mile square. The township is 6 miles square, not 36 square miles. Okay, it's 1 mile square, 6 miles square, meaning each side is 6 miles, and up and down the meridian and the baseline across, there's 6 miles. So if you have 640 acres and you want to find out how much 10 acres is, well, it's 10 divided by 640. Therefore, you reduce it. And if you know what I mean by reducing a fraction, you get rid of the 0. You end up with 1 over 64. Oh, okay. You scheduled your test for the 28th. All right. We wish you lots of the best, not just luck, because it takes more than just luck. Okay. It takes a lot of dedication and preparation and commitment. Just don't beat yourself up when you don't pass. You're not a failure. Keep that in mind. Okay. We're not failures when we pass. We just need to find a better way to study and learn and master taking the exam. All right, number 27. So the lot and block system of legally describing property is used for what? A, farm properties. B, any property in an unincorporated area. C, properties with meets and bounds is not acceptable. Or D, properties in a subdivision. Lot and block. So if we're here in the city, right, we have different blocks and we have all these little lots in the plat map. Okay, so who's my Facebook user on here? So Facebook user, go to StreamYard.com/Facebook, and it's a real quick step to do that. Okay, that's Jaslyn. Yeah, Jaslyn. So go here, StreamYard.com/Facebook, and give StreamYard permission so that we can see your name like this. Okay, instead of Facebook user. We want to know who you are. So hi, Anna. Hi, Jaylene. So the answer, yes, is 27D, properties in a subdivision. That is the lot and block. A government rectangular system is more for large acreage. However, here in our cities, even farm property is divided into acres, okay? Or they have a zoning of a 10-acre parcel, a 20-acre parcel, 30-acre, 50-acre. So there's different zoning on how agricultural land can be subdivided. Hi, Brittany. Thank you for joining us. So 370, 327D. All right, so we're here to practice national questions and get prepared to pass, right? Right. All right, number 328. Let's see if I can make that larger for you. Yes. Okay. So a certain legal description contains the phrase northwesterly long Erie Road, a long Erie Road to the point of beginning. What kind of description is this? A plat survey, B, government grid, C, meets and bounds, or D, rectangular survey? Type your answer in the chat. So it says a certain legal description. Okay. That is the key word, legal description, contains the phrase. What kind of description is this? Not like in the others, what kind of survey or block, lot and block or government system is it? Oops, I went the wrong way. All right, so I've got CCC. Very good. Yes, 28C. Awesome. Hey, Brittany, if you could go, not hey, hi, Brittany. If you could go to StreamYard.com/Facebook really quick. It takes, 15 seconds, 30 seconds, and give StreamYard permission to post your name on here instead of this way. Okay. You'll get to see like Cindy's. We all want to know who you are. On Facebook, your name shows up, but not on here because we're streaming. All right, number 29. So yes, that was great, right? On a lot and block type of survey, it'll have a description that is the meets and bounds. That's like explaining all the directions from the start point back to the start point, okay? The point of beginning, that's what POB is. It describes all the process. If there's angles, it'll point the degrees, the name of the street, if there's streets, northwest, southwest, southeast, in the block and lot, I'm sorry. In the rectangular system, it'll say like the northeast 1/4, southeast 1/4, and that's how they determine it versus using the lot and block and then this type of a description. But that was the key word, legal description. What is the description, right? So it's not a survey, it's not a grid, it's not a survey, right? So that would help you select the correct answer. Okay, number 29. Okay, number 29. How many sections are there in a township? I just mentioned that a little bit ago. A, 1, B, 6, C, 12, D, 36. How many sections in a township? Hi, Uma. Thanks for joining us. Type your answer in the chatty chat. And that is correct. It is 36, right? I showed the 36 on here. Right, so a township is divided into 36 sections. That was not it. So you can Google it online and, it's a government congressional township rectangular survey grid. And you'll see that there are 36 and then each one gets divided into quarters and quarters and quarters and quarters to find out how many acres there are in a particular description. All right, so, oh, did I type the answer yet? No. So very good, 329D. Did everybody get it right? D, 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 D. Yes, yes, yes. Okay. Number 30. Again, rectangular system. In the rectangular survey system, a section contains how many acres? Type your answer in the chat. Remember the answer in the prior question? It asked us what part of a section is 10 acres? Very good. Yes, A, 640 acres. Awesome. So each quarter, so if the whole township, the whole section is 640 acres and you divide it in quarters, how many acres in each quarter? Type the answer in the chat. How many acres in each quarter of a section? What the heck? Oh, nobody's typing that in. So 640 divided by 4 gives you what? 160. Very good, Kathleen. Very good. So it's 160 acres. And remember to always, I know on the answers they didn't type down acres because the question says how many acres. If you're ever having to type an answer or write it in, always remember to write the units. It's 160 acres in a quarter of a section. Very good, because the whole section is 640 acres. Number 31. The valuable consideration necessary to make a contract valid must be, okay, the valuable consideration necessary to make a contract valid must be what? A, money. B, something tangible. C, something of value traded in exchange for something of value. Or D, something of equal value with whatever is received in exchange. So valuable consideration that makes a contract valid. Very good. Yes. 331 is C, something of value traded in exchange for something of value. Very good. Hi, Lisbeth. Good afternoon or good evening. Still daylight. Sun still is out. I went for my 1 mile walk and jog with a puppy dog. All right. Everybody got that right. Awesome. All right. Number 32. A real estate sales contract to be enforceable must have what? A, contain a legal description of the property. B, be written on a form approved by the State Bar Association. C, be acknowledged by 3 witnesses. Or D, be recorded within 3 days to be enforceable. So in order for a sales contract, okay, to be enforceable, what must it include out of those answers? Of course, it requires to be signed, have a start and end date, okay, but those are not options, right? So the correct answer is A, contain a legal description of the property. That's how properties are identified in all types of documents and documents recorded. Awesome. Very good. Oh, Cindy, no, it's not B. To be written on a form approved by the State Bar. No, 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 no. The promulgated forms are approved by TREC, remember? And TREC has a 13-member committee, the broker and lawyer committee, right? So there are 6 lawyers, 6 brokers, and 1 civilian. So they are not approved by the state bar. No, no, no. The 6 attorneys are approved by the state bar. All right, number 33. You got that, Cindy? How much time does a seller have to accept a buyer's offer? Good job, Cindy. How much time does a seller have to accept a buyer's offer? A, 48 hours from the time of the offer signing of the offer. B, 24 hours from the time of the offer's delivery to the seller. C, within 24 hours following the stated expiration. Or D, a reasonable time or until the expiration date on the offer. Awesome. Got it. 33D, right? A reasonable time or until expiration date on the offer. So they could put on the contract that please respond, in the special provisions, because the contract doesn't specify that a buyer or a seller has to reply on an offer or a counter within a certain number of hours. Certain states do. However, Texas real estate contracts do not. However, it can be included in there. Some individuals can take a while, and it's really time is of the essence. It's important. It's a stressful time, can cause anxiety and fear of the unknown when there are properties being sold and purchased. So when there's a contract, it's important to move pretty quickly, 24 to 48 hours, and keep notifying the clients through the realtors, right? Because we only interact with our client. 34. So communication is important. And nowadays we can communicate through text, email, phone calls, messenger, WhatsApp, for international individuals. There's so many different ways. 34. A buyer submits an offer to a seller and then dies in a car accident. Before learning of the buyer's death, the seller accepts the offer. Which of the following is true? A, the seller can force the buyer's estate to go through with the purchase. B, the buyer's death terminated the offer. C, the seller must take a new offer with the same terms to the buyer's heirs. Or D, the buyer's heirs have an option of enforcing the contract. Awesome. Very good. The buyer's death terminated the offer. Unless the offer said and or assigned to someone else. So there's a new individual on there, but that would have been known when it was taken to escrow. Okay, that would happen at the escrow point. Because individuals, wholesalers, okay, can end up finding properties. We're on 330. No, we're on 34. Okay. So wholesale buyers and sellers, okay, they're like the middle person, but they don't have to be licensed because they're not representing anyone. They're in the middle and they get paid at closing. They're not earning money on behalf of someone that they are representing. So they tie up a property by writing a contract, and it'll say and or assigned to someone else. Number 35. You all did awesome on that. Which of the following contracts can be assigned to another party? Why? I was just talking about assignment, right? A, an exclusive listing agreement. B, a personal services agreement. C, a contract for the sale of undeveloped land. Or D, an employment contract between a broker and a salesperson. So which of the following contracts can be assigned to another person? Hootie Tigger, what's up? You got food? You hear my neighbor's cat? C, that's correct. It is a contract for the sale of undeveloped land. So why is it that one? And it says undeveloped. So a contract is used, right, when you're a wholesaler, okay? It can be assigned, or it can be assigned to an LLC or something like that. There doesn't have to be a wholesaler. However, it's the purchase or sale of a property. So this contract for sale, okay, is the key word, contract for sale. An exclusive listing agreement, no, is only with the seller, the owner of the property. That cannot be assigned to somebody else unless it, now there's a power of attorney, and a power of attorney is the one who has the power to sign for the owner. So that'll be amended on the contract, and that power of attorney will sign, but it's not being assigned to another party. So the only one that fits this here is a contract for sale, because in order to assign something, it's a contract typically to sell a property. Undeveloped land, unimproved land, commercial, residential, industrial, agriculture. Okay, you've got it. Very good. All right, number 36. Oh, Pootie, I'm teaching a class. We're tutoring. You want to teach a class? All right. I'm a cat lover, you all. Actually, I'm an animal lover. Okay. All right, 36. An implied agency relationship may be deemed to exist if, okay, an implied agency relationship may be deemed to exist if A, the parties do not disavow an express contract that has expired. B, the parties act as if there is a contract. C, an offering party does not receive written notice that the offer has been rejected. Or D, the parties promise to perform their part of the agreement if the other party performs. So an implied contract. Very good. Yes, it is B. The parties act as if there is a contract. So an implied agency relationship. So there's a contract between what? The broker and the client, right? There is an agreement. Very good. I think everybody got it right. Yes. Have it together tonight. Number 37. Which of the following is an executory contract? Okay, vocabulary here. A, an expired lease. B, a sale contract before closing. C, a recorded sale contract. Or D, an option to buy after it's exercised. It is exercised. Type your answer in the chatty chat, and I'm going to give this kitty cat some extra food. Foodie Tigger. All right, so what do we have here? B, C, oui, monsieur. The answer is B, a sale contract before closing. So a contract, when we, executory means it's waiting to be closed, right? We execute a contract and we say the contract is executed, and when it closes, it's executed. But a contract before closing is called executory contract. Now, you will see in the resale contract 1 to 4, right, that you normally study, the 1 to 4 family resale contract. That has on there the effective date, which is called the executed date. That's the executed date between everyone coming to agreement and signing and typing initials. Okay, then it's taken. So at that point, the contract was executed, but not the sale. So then it goes into, it's an executory contract waiting to be closed. Okay, so it's a sale contract before closing. All right, so very good. That used to get me mixed up too. So don't feel bad if it mixes you up. I'm like, well, I thought it was executed. Well, that is the contract, not the sale. Two different steps in the process. Oh, come on. Gee. Okay, there. All right, number 38. A bilateral contract is one in which, there's bilateral, unilateral, trilateral? No. So bilateral, unilateral, right? So a bilateral contract is one in which A, both parties promise to do something in exchange for the other party's performance. B, both parties receive equal consideration. C, two parties agree to perform a service together. Or D, both parties promise to do something if the other party performs first. Yes, awesome, very good. So 38A, both parties promise to do something in exchange for the other party's performance, right? Each party has specific performance according to the sales contract. When it's in the option period, then it is what? Type that in the chatty chat. When the contract is an option period, who has to perform? Both parties or one party? Type the answer in the chat. Come on, take a risk. So during the option period, it's a unilateral contract. No, the seller is not. It is a unilateral contract. It's one-sided, right? Only the buyer has to perform. The seller is waiting for the buyer to finish their due diligence, their inspections. Okay, during the that's in one section where time is of the essence. So the buyer has to make a decision before the number of days that they requested to do inspections and paid an option fee, a certain amount per day. So only the buyer has to perform. The seller just waits. But there is a deadline, okay? That one does have time is of the essence. Okay, number 39. But yes, it's called unilateral. 39, a home seller signs a listing agreement with a broker, then subsequently revokes the listing. So home seller signs a listing agreement with the broker, then subsequently revokes the listing. Which of the following is a true statement? A, The seller continues to have contractual obligations with the broker. B, the contract remains in full force until the expiration date. C, the broker may have a claim for marketing expenses expended during the listing term. Or D, the seller cannot sign a listing agreement with another broker. So home seller signs a listing agreement, so there's an agency relationship, right? Then subsequently revokes the listing. The answer is C. The broker may have a claim for marketing expenses expended during the listing term. So if the listing agreement specified that the owner would be responsible for certain marketing expenses and they terminated the listing agreement and the broker allowed them to do so, they may have to pay certain fees. Because we already spent money for marketing, advertising, if it is spent. And it could be administrative time. You have a virtual assistant, you have an assistant. Okay. It says they may. Okay. So the broker may have a claim, not the broker does have a claim or must have a claim. Keyword may. They may or they may not. And most of the time, they don't. Now, on a commercial contract, that's different. There's a lot more work that goes into commercial real estate. And it's more expensive to be a commercial realtor. You notice how I said realtor? There are two syllables, real and tor. So learn to pronounce the word carefully. I read a book by one of EXP's top producers, and she says, okay, be educated from the beginning. Learn to pronounce the word. It has two syllables, real and tor. Realtor, not relator. Okay? But don't feel bad. I used to say realtor also until, I'm looking at it, or somebody pointed out to me, realtor. It's a little bit more challenging to say realtor. You almost have to emphasize that tor. All right, number 40. So how many of you knew that it was a two-syllable word? How many knew that it was real dash tor, not realtor? So I was going to say, well, you can raise your hands, but you can't. Can't raise your hands on here. So anyway, you're going to learn from me. It's realtor. All right, number 40. I saw a guy jokingly say the second A is silent. Oh, really? He must have been joking because there's no A in realtor. Okay. That's funny. You see that? I saw a guy jokingly say yes, because there is no A, right? So it's silent, doesn't exist. Number 40, a breach of contract is A, termination of the contract by mutual consent of the parties. B, financial damage suffered by a party because another party has nullified a contract provision. C, a lawsuit to force a party to discharge the contract. Or D, the failure of a party to perform according to the terms of the contract. All right. Uma says that learned it from there. Awesome. And let's see. Somebody else said, I knew it. Says, right, because they say it like that. Yes. So Melanie's, she knew it. Awesome. So you're going to learn how to say it right. So number 40. Yes, 40D. D, so a breach of contract is failure of a party to perform according to the terms of the contract, right? So they violated the specific performance that each party has. That's what it's called, the specific performance. So you've got the keyword perform, right? A breach of contract is failure of a party to perform, to do their specific performance. Therefore, there are liquidated damages. Most of the damages are, by the buyer if they terminate without cause, then they lose it. Hi, Miss Stacy. Hey, you arrive. Whenever you arrive, you're on time. Okay, that is your time. She says, "Hi, everyone. I'm late." No, you arrived at the right time for you. Okay, my goal is to keep it all positive and make you feel good. Okay, it's enough stress and anxiety preparing for exams. We don't need any more. Okay, so you got that? So let's say A said mutual consent. No, that's not a breach of contract. If they have mutual consent, they win an agreement, then they get out of it. Financial damage suffered by a party because another party has nullified a contract provision. No. A lawsuit to force a party to discharge. No, the lawsuit is like litigation that happens after mediation, arbitration, and all that. So the contract itself already has specifications of what happens in the case of a default seller or buyer. If the buyer defaults without good reason, they lose their earnest money. So they fail to perform. If the seller fails to perform and they back out, decide not to sell, they're still they still have to pay the commission, and the buyer could take them to court litigation and say, I want that house. I already spent a lot of money, okay, with all the inspections and other costs. And some sellers will do that. It's unfortunate. Most of the time, the buyer doesn't take them to court, but they may demand, okay, all the costs that they put into it to be refunded. And they are due the commission to the brokers because we did our specific performance, right? We earn, okay? We don't get paid. We earn our money when we bring a ready, willing, and able buyer, okay, to the seller, and the contract is executed, okay? They come into agreement. That's when we earn our money. We get paid when it closes. Big difference. So 41, what is rescission? A, the act of withdrawing an offer before it has been accepted. B, the act of declaring that a contract is no longer in effect for a given party. C, the act of declaring a contract unenforceable. Or D, the act of modifying the terms of an offer. Okay, so far we have B. And more B's. Anybody else? And yes, the answer is B. The act of declaring that a contract is no longer in effect for a given party. So someone rescinded their contract, right? Yes, okay. Okay, 42. So the answer, did I type it? 41B. Very good, y'all. To be valid, a valid contract must include what? A reflect a mutual understanding or agreement. B, use precise wording in a document. C, not be executable. D, be created only by an attorney. So what makes a contract valid? Awesome. Yes. A, reflect a mutual understanding or agreement, right? Because when they're in agreement, then they're all going to sign and then it is executed. A contract is valid when everybody comes to an agreement. Awesome. All right, number 43. Two parties enter into a contract. The agreement fulfills all the requirements for a valid contract with no disqualifying circumstances. Now, given this situation, it is still possible that the contract may be what? A, void, B, illegal, C, unenforceable, or D, voidable. Think about this carefully. So they enter into a contract. The agreement fulfills all requirements for a valid contract with no disqualifying circumstances. Given this situation, it is still possible that the contract may be no, it is not voidable. Okay, because it's already a valid contract. That it may not be enforceable. It may be an unenforceable contract. Let's see what the answer says here. A valid contract that is in writing is enforceable within a statutory time period. A valid contract that is made orally is also generally enforceable within a statutory period, like for lease agreements, right? With the exception that some contracts are enforceable only if they are in writing. These laws apply in particular to the transfer of interest in real estate. A void, meaning a large empty space, so a void or voidable contract was not truly a valid contract. Okay, so a void or voidable contract were not valid contracts. So that's why it is not A, void, or D, voidable, because it was already a valid contract. So that only leaves one. And it's not illegal because it is valid. Okay. Therefore, if they were to take it to court, there may be some things about it that would make it unenforceable. I think I already typed the answer. Yes, I did. Okay. So most of you answered C. I have an A, D. Yeah, so it is not void. So remember, a valid contract, okay, is a void or voidable contract was never a valid contract. So when it's valid, it's a good contract. Okay, there's only one thing. It may not be enforceable. And at the moment, I don't have an example to give you. Maybe somebody lied, okay, or specified that they had the money to pay for it, okay, and then they don't, so they can't enforce it in court. Okay, that could be, one example. Or somebody signed for someone else without a POA, and we don't know until it goes to escrow. So it was a valid contract because both parties signed. There was a consideration, which doesn't have to be money, right? Okay, number 44. The guardian of a mentally incompetent party enters in an oral contract with another party to buy a trade fixture on behalf of the incompetent party. This contract is A, does not meet validity requirements. B, is possibly valid and enforceable. C, must be in writing to be valid. D, is valid but unenforceable. So the guardian for a mentally incompetent party enters in an oral contract with another party. Because remember, certain oral contracts can be valid and enforceable. So no, it is not C. The correct answer here, as Melanie states, it is B. It is possibly valid and enforceable. Because it doesn't say, it says they're buying a trade fixture, okay? It's not, real estate. So it might be a bargain and sale. So it's a verbal purchase. So that one is possibly valid and enforceable. We don't know yet, but oral contracts, as it said in the prior question, right? It said a valid contract that is in writing is enforceable within a statutory time. However, a valid contract that is made orally is also generally enforceable within a statutory period. Okay, with the exception that some contracts require being in writing. This one may not be required to be in writing. So that's why it says is possibly valid and enforceable, because they came into a verbal agreement, right? The only document that is a sales contract, okay, for real estate, or I'm sorry, that can be less than a year, right, is a lease for less than a year. That can be oral and it will be enforceable. I mean, they'll have to show proof. Well, in order to be enforceable, right, a contract must be in writing. So an oral lease, even though it doesn't have to be under a written contract, it can be oral. In order to enforce it in court, yes, they'll have to bring it into writing. So when we have a lease client and there are no rental agreements, okay, their agreement is verbal, we have to fill out an estoppel form from each of the tenants specifying this is how much my rent is, and I'm on month to month, or I'm on a year, and this is what I paid for deposit. So there's a record of it. So you'll learn that as a realtor, should you ever represent a seller that rents properties and doesn't have written leases. Because some individuals, older generations, still like to do things by handshake, okay? And they still believe that, trust an individual, and they keep a close eye on it. They live on the property, okay? So that's much easier to control on a handshake type of thing. All right, number 45. A prospective home buyer, submits a signed offer with the condition that the seller pay the inspection at closing. The seller disagrees, crosses out the provision, then signs and returns the document to the buyer. At this point, assuming all other contract validity items are in order, the original offer is now what? A, an accepted offer, therefore a valid contract. B, an executable option. C, a counter offer. Or D, an invalid offer. Type your answer in the chat. All right, Melanie's. It is not an invalid offer. It is a counter offer. So it's like a new offer. Okay, remember when a seller or a buyer counters, the first offer is replaced by the new one because they made changes. So it's by novation, we have a new offer and we call it a counter offer. It is not an invalid offer. So it's just the seller didn't want to pay for the inspection, and we deal with that. So then the seller counters and says, no, I'll accept everything except for buyer pays their own inspection. So what we do is we, cross that out, put a new box, write in the date, and that could be in the one of the specifications on there, whether they're going during the option period, okay? And they could say in the no, I'm sorry, take it back. It's in the settlement and cost section, okay, of the contract, and they can ask for closing costs for certain expenses that the buyer has. And so we're entering now into a market that buyers can ask for some closing costs because there's not all properties are getting multiple offers. So yes, it is a counter offer. What time is it? 6:56. Okay, we started with 26. Okay, so we've done 20 questions for national. Okay, any questions on the national part? Y'all did really good on this today. I should say all of you did really good on this today, but I like y'all. Okay, so state questions next. So give me a moment. Anybody watching the replay, you can fast forward while I change gears. Oh, not delete. Okay, and so change your thinking cap on. Oh, 282, sorry. And get ready for, some Texas law. I'll show you what the topic is in the moment. Okay, something's not working right here for me. All right, there we go. All right, thank you. You're really an inspiration. Oh, thank you very much, Melanie. I appreciate it. That's my goal, is to inspire all of you to, don't be so hard on yourself if for some reason you don't fail, okay? Because you don't fail. You don't pass means you just got to change your method of studying, study some more, review the material from any prep book that you have, or any videos that you're watching. Oh, what the heck did I do here? Hide. And just keep studying. Doesn't mean it wasn't meant to be. If you really want this, you've got to reevaluate your situation, how you're studying, your approach, what you're studying, how much time you're giving yourself and doing every day, and get your mindset prepared to study and believe. Do not fear. Fear causes us to stop doing what we want because fear is the unknown. Fear is tomorrow. We don't know what's going to happen tomorrow. So don't fear it. Fear is not real. Okay. Even though I do sometimes have fear. Okay. However, I've learned that fear is tomorrow. And so it brings anxiety. Okay. It can bring depression, but it's not real. Most of the times it comes out okay, right? You're still here. You may find out that, yes, you definitely want to do this. Or you say, well, you know what? I really don't want to do real estate after all. And that's okay. It's like when we're going to college, right? We might change our major multiple times. All right, these are Texas State questions. Which of the following is true regarding the Texas Real Estate Commission? A, commissioners serve staggered 3-year terms. B, 9 members are elected to 6-year terms. C, 3 members must represent the public. Or D, 6 members are appointed by the governor with the approval of the Senate. So which of the following is true regarding the Texas Real Estate Commission? So yes, the answer is C. Hi, Naz. Thank you for joining us. 3 members must represent the public of the commissioners. All right. Hold on, y'all. Somebody keeps knocking. Sorry, but I'm teaching a class, girl. Oh, you guys are doing that? Okay. Come in and I'll give it to you. I'm teaching a class, so it's not the right time. Okay. So hold on. I lost track. We're on number 2, right? Yes, we are. Okay, there. So, hey, y'all, I'm going to take a COVID test. Okay, not that I have COVID. It's just a preventative. Okay, so review that question. The TREC is empowered to do what? A, enact laws to administer licensed law statutes. B, discipline violators of licensed law. C, establish uniform standards of business practice, including market area delineations and commissions. Or D, impose incarceration sentences for flagrant violators of licensed law. I'll be right back. Type your answer in the chatty chat.
Oh, I forgot. Was it weird?
That one's in the nose.
Oh,
No good.
it's okay though.
I don't know if it's going to work.
That's good.
Tell your mom.
Right, okay.
Girl. Ooh. Bye. All right. Who got it right? Thank you. Bye. Love you. Dang, I just have to stick a Q-tip up my nose, man. That hurt. The TREC is empowered to do, excuse me, discipline violators of licensed law. Okay, so sorry, you all, not right. Okay, so discipline violators of licensed law. So TREC is charged with the responsibility to administer and enforce licensed law, including disciplining violators. It does not, however, enact laws as such as the province of the legislature, nor can it impose jail sentences. Further, TREC does not regulate day-to-day brokerage operations such as market area definitions or commissions. So whoever answered C, no, it does not establish practice standards of business, including market area. Okay, That's up to us. We have to follow the policies and procedures of whatever broker we go to, but we're running our business the way we see fit. So as long as we follow the rules and the laws, they don't impose incarceration sentences, okay, for flagrant violators, and they don't enact the laws, okay? That's the Texas legislature. Yes, okay. Oh, thank you for your patience. Anybody that was watching this, hey, just fast forward, but now it's too late. So it's a preventative system, okay, to prevent or to find out, whether we've got COVID in advance. The state of Texas has put that in place. So a lot of people do free COVID tests and they can come to your home, just like my neighbors. So do y'all get that? Okay. Why you missed it? Because I think, let's see, we had they don't enact laws. That's the legislature. Okay. And they discipline violators of license law. That's why they will have people individuals, okay, or other realtors can file a complaint and TREC has to investigate it. And if they find that it's valid reason, then they'll hold a hearing and then make a decision. So they discipline violators, and it can be up to a year in prison. However, they don't impose the incarceration sentences for flagrant violators, nor do they establish uniform standards of business practice. Okay. Realize that, learn this. We have done a lot of these questions before. Okay, did I type the answer? Yes. So that was B. Okay, got it? All of those that selected enact laws. Nope, they don't need to enact laws. You might be thinking that because they have a 13-party committee, the broker, the lawyer, and one civilian to write the promulgated contracts, but they don't enact the laws. That's from the Texas legislature. So go back and review what rights and authorities TREC has, Texas Real Estate Commission, okay? Number 3, the purpose of the Education Standard Advisory Committee, ESAC, know your acronyms, is to A, establish and maintain education standards for fulfillment of the education-related aspects of Texas license law. B, hire and manage real estate examination consultants to deliver the state license examination. C, approve the delivery performances of real estate instructors on an ongoing basis. Or D, standardize education requirements for licensees and schools. Type your answer in the chat. So anybody who's just joined us, we're doing Texas state questions. And thank all of you for attending. There's a whole bunch of you on here tonight, and that's exciting. That makes me happy. And so for anybody who's watching on YouTube, hey, remember to click that thumbs up, all right? And show me some love. Send me some support so I can give me encouragement to keep doing this. There's a whole bunch of you on YouTube, and I only have 5 thumbs up. Okay, so I've got D. Anybody else? DD. Ooh, DDD. No, the actual answer is A. Establish and maintain education standards for fulfillment of the education-related aspects of Texas license law. So the answer says the ESAC operates in an advisory capacity. That's the Education Standards Advisory Committee. Okay, so it is in a capacity to TREC, to establish specific guidelines and standards for teachers and schools in fulfillment fulfilling education-related licensing requirements. It cannot in itself establish license requirements, nor not does it serve to deliver and administer the license exam. Finally, while it may establish teaching standards, it does not literally audit delivery performances of instructors. So that's another one. So what you say, Naz? Damn, always go with your first answer. Yes, that's why they say don't change your darn answers, right? Only if a future question, okay, or a past answer helps you, reminds you to, hey, oh, I better go and review that during the exam, right? When you have a little extra time, and then you can go and change your answer. Because another question may help you answer it correctly. Then you can change it. But if you're doubting yourself, might as well leave it. Because that's what happens. We fear it. A lot of us doubt ourselves. So the answer is A. So most of you answered D. Standardized education requirements for licensees and schools. No, so they establish and maintain education standards, okay, for fulfillment of the education-related aspects of Texas license law. They establish and maintain, okay, the standards. So again, the answer was the Education Standards Advisory Committee, right? They're an advisory committee. So they don't do the standardizing. So they are in an advisory capacity to TREC, okay, to establish specific guidelines and standards for teachers and schools in fulfilling education-related licensing requirements. So they don't standardize the education requirements. They're the advisory capacity to TREC, to establish specific guidelines. Okay, so they establish the guidelines and they monitor that, they advise TREC. It cannot itself establish license requirements. So they don't establish the requirements, nor does it serve to deliver and administer the license exam. That is monitored by TREC, right? Because TREC has to approve. All the schools and instructors all have to be certified and accredited by the Texas Real Estate Commission. Number 4. Did y'all get that? Because almost all of you answered D. Okay, so they do not standardize education requirements. Okay, they're an advisory committee. It cannot establish license requirements. So they're an advisory committee to establish the specific guidelines. Number 4, in fulfilling its regulatory role, TREC, Texas Real Estate Commission, is empowered to do what? A, convict licensees of misdemeanors or felonies. B, dissolve offending business entities such as real estate management companies. C, amend license law if deemed to be illegal or unfair. Or D, impose fines as well as suspend or revoke licenses. So what can they regulate? What are they empowered to do and approved by the legislature? Hi, Brooklyn Daddy. Thanks for joining us. We're doing Texas State questions, so maybe you're studying for the Texas State, but if not, hey, you can learn and pick out, little keywords that help in answering, different types of questions. Oh, I put it 11D instead of 11.4D. I put, gosh, my internet is the pits today. It's like I click, and oh, well. You need it. Okay, you're studying for your Texas real estate license. So how many kids do you have, Mr. Brooklyn Daddy? Or that's just what your wife or girlfriend calls you? All right. So anyway, I'm getting off the topic here. Just trying to bring some humor. We all could use a little bit of humor to relax, right? Number 5. If a licensee suspension, lots of left. Oh, check it out. He's got 6. Awesome. I come from a family of 7. Yo. Awesome. Okay. If a licensee suspension is upheld following a hearing, the licensee is what? So licensee suspension is upheld following a hearing. The licensee is what? A, may appeal to a district court where the hearing was held. B, may appeal to an appellate court where the violation occurred. C, may sue in district court for injunctive relief. Or D, may not appeal the correct decision. Hi, Tamar. Thank you for joining us. We're doing Texas State questions, Tamar. This is your first time here. Yes, you joined our private Facebook group. Yes, number 11.5 is A. No, Naz. So first, they appealed to a district court where the hearing was held. Okay, first you appeal to the closest court. So that's the court where it was held. Either it was held in Austin or in the county district court where the realtor or the person resides. So let's see, same first time here and just started my Texas prep. Oh, all right, Naz. Yes, yeah, you're right. The first time I see you here. Welcome. Oh, and thanks, DB Fitness. Thanks for joining us tonight. We've got an awesome crowd today. To all of you who just joined, we're doing Texas State questions. And if you're watching on YouTube, which a lot of you are, remember to click that thumbs up and send me some love. Love that love. And I keep doing this. All right, number 6. All right, 11.5. Okay, very good. All right, number 6 here. Which of the following is true regarding the Texas Real Estate Recovery Trust Fund? Okay, the Texas Real Estate Recovery Trust Fund. What is the Recovery Trust Fund for? Okay, must know that. A, licensees must prominently display Form 1-1 to consumers, advising them of the importance of the caveat emptor. What is that? Buyers beware, or let the buyer beware. B, licensees fund the trust account through fines and judgments issued by the TREC. C, the trust fund exists to assist licensees in financing the payment of judgment to consumers. Or D, licensees must disclose to consumers that there is a trust fund in Texas to satisfy judgments and reimburse parties damages from the actions of licensees. Oui. Yes, the answer is D. The trust fund, the Texas Real Estate Recovery Trust Fund, okay, is for advice that we must disclose to consumers. That's one of the forms that we share, right? I think is the Form 1-1. That there is a trust fund in Texas to satisfy judgments and reimburse parties, okay, for liquidated damages from any actions where a licensee was found guilty. And that licensee will have to reimburse, okay, the trust fund. Who got DDD? Lots of DDDs. Very good. So Tamar, I hope I'm pronouncing that correct. Yeah, the trust fund exists to assist licensees. No, it's not for financing the payment of judgments to consumer. No, 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 no. Consumers bring judgment against realtors and brokers, inspectors, and easement right-of-way individuals and property management, not the other way around. So it is used for liquidated damages when a client wins against a complainant. So Tamar, wow, glad I'm here. I thought it was C. Yes, we totally understand. So no, it is not for the benefit of licensees. We have error and omission to help protect us from any complaints, any issues on a contract. Okay. But it goes, first there's a hearing at TREC when somebody is complained about. But before that, TREC has to do the research and find out if it's a valid complaint. Okay. Before they actually request a hearing and the issue a subpoena for the licensee to attend, and they're given the choice to attend in their own court, district court in the county where we reside, or if they don't reply, it goes to Austin District Court. Oh, great, Tamara. I'm saying correctly. All right, y'all. So real estate recovery trust fund is for the consumer, okay, when they win. Error and omissions protects us. When we screw up errors, when we make errors in contract, okay? And so whether we're guilty or not, the error and omission is there to fight for us. In some cases, there may be $1,000 or more deductible. All right, number 7. Oh, did I type the answer? Oh. Let's see here, number 7. Which of the following is true regarding one's license status? A, sales agents who will be suspended must notify their broker in writing 3 days prior to the suspension. B, brokers who will be suspended must notify their sponsored agents of such an action within 7 days following the suspension. Really? Excuse me. C, if a sales agent's license is suspended, the broker has 7 days to request a hearing. Or D, licensees with suspended licenses may continue paid advertising, but must immediately cease all other brokerage practice. So which of the following is true, okay, about our license status? Okay, so Lisbeth says 7A. The many of you that are here, come on, participate. This is for you. Of course, if you're driving, please don't be typing, okay, and texting and driving. However, if you're sitting at home or you're sitting watching on a phone, on your computer, or on your TV, participate. We're here to help each other out. And thank you for the love. Yes, the answer is A. Sales agents who will be suspended must notify their broker in writing 3 days prior to the suspension. Because of course, TREC will know before, okay, that there's a suspension, but they will know, and so will the sales agent. So they must notify their broker within 3 days prior to being told they're going to be suspended, or they're being suspended. Okay. See, we had a B. So B, brokers will be suspended, must notify their sponsored agents of such action within 70. No, I mean, if a broker is already licensed and suspended, okay, they are inactive. All realtors under a broker, hanging their license under a broker, they are immediately inactive. Okay, so immediately must find another broker to put our license, and everything has to be removed. If you have a bunch of listings, they have to be removed. If you have contracts, they have to be moved immediately, okay, to another broker. So as soon as a broker is suspended or the everybody else's license is inactive, if that's the only broker of that company, because sometimes you have a brokerage and you have managing brokers or a sponsoring broker for the whole organization. So if that broker is suspended, there may be other managing brokers. Everything has to be moved to their name. Okay. Some little companies have one broker, and that's the owner of a little boutique company. Okay. But major corporations, major large companies, okay, will have multiple brokers. They have one major sponsoring broker, and then they have other managing or associate brokers. I almost typed the answer A. B. So let's say a question here. What are some of the important reasons a license may be suspended in Texas? That's hard to say, Naz. However, if somebody did something illegal, or if they misrepresented a client, okay, and they were found guilty, it goes through a process. It's not like instantaneous. Now, some companies, when they find that clients have been complaining about a particular broker, they can suspend ASAP. They can, turn it into TREC, and they will release them from their organization. And that can happen instantaneous. It's like losing a job at a company at will. They can walk you out the door when you're fired ASAP. That can happen in a brokerage when they have multiple brokers, the supervising broker, the sponsoring broker, and managing brokers or associate brokers. Okay. They may move an associate broker up to managing broker or the supervising broker. So there's different levels of that. So anybody that is misrepresenting clients, lying, if they're an intermediary and they end up advising one client over the other, that is not acceptable. Because remember, when you're an intermediary, they mediate. The clients are represented by the sales agent for the seller, sales agent for the buyer. Okay. Or they're in a major accident, maybe alcoholic or whatever. So there's got to be major cause, and it has to go through the review. Certain things can happen instantaneously. Okay. Like I mentioned, somebody telling them, hey, you're out of our brokerage, because it's not a one broker owned company, like a small boutique. So there's going to be, I've never been in a situation, okay, where a broker's license has been suspended, because I've been with franchises and now a major corporation where we have multiple brokers, the supervising broker and then managing brokers. Okay. And, that's very carefully done. But in small operations, okay, that can happen. And I had a friend realtor that was under a small boutique company, and that broker violated strictly bad, okay, laws, and they were suspended. Well, what do all those realtors have to do? They're inactive immediately. Okay. When the broker is suspended, they go inactive. Okay. They're not in review. They go inactive, and all the realtors under them go inactive ASAP. So all those realtors must get someone else immediately and transfer all their contracts and all their listings. Okay, so Tamar, it's obvious that agency and brokerage was my weakest area. It is. You're not alone, Tamar. It is a weak area for many. So did I type the answer? I lost track here. 11.7a. Yes, I did. Yes. Okay. So thank you for your questions. All questions are good. Don't be afraid to ask. I know the answer. I'll let you know. If I don't, I'll Google it. Okay. I have been in the business a few years, okay, and in 3 different markets and two different states. I was in Oregon for my first 5 full-time years. I did it part-time at first, and real estate is not. You're very welcome, Naz or Naz. It's not for really part-time, unless you're a very aggressive workaholic and you can work 2 full-time jobs, okay, or 2 part-time jobs. All right, number 8. Very good question. Which of the following is true regarding complaints? A, they must be filed within 4 years. B, they may be conducted covertly without the knowledge of all parties. C, they are adjudicated in the order they were received. Or D, they must be investigated regardless of their apparent merit or lack of it. I made a comment about, what TREC does when they get a complaint. So think about that. And there are usually statutes of limitations with anything, right? Oh, Naz, it's not D. Sorry. So the answer here is A. So Uma, Jaylene, Cindy Cook, Kathleen, all of you got it right. Okay. It is A. They must be filed within 4 years. So if a client or that we had an agency relationship, okay, filed a complaint, it has to be 4 years from the contract or the closing, from the time that they were represented. Okay. I'm losing track of where I am. And therefore, we keep our documents. Oh, I typed the answer twice. For 4 years, right? Some states are required to keep all your documents for 6 years. Now we can keep all our documents online with the brokerage. I like to download them and keep them on my Google Drive and have my own copy, because I've had clients from years ago, 10 years ago or so, will call me and say, Lillie, do you still have a copy of my settlement statement or something like that? And I will typically be able to find it because of how I organize my Google Docs of all the files that I have represented and closed contracts. Okay, so that was the last question on that section, which it has to do with Texas Real Estate Commission, right? So that section should help you understand whether you need to go back and study it some more, right? So now we're going into licensing regulations. So any questions? So Tamara, you knew this. All right, good, awesome. Doesn't that feel good when you really know it and you're definite about it? Yes, it does. However, if you don't, hey, don't punish yourself like I used to. Don't be so hard on yourself. Don't go throw up and get sick to your stomach. It's okay. One step at a time. It's just letting you know that you've got to do more studying, more prepping, more review the prep books. The prep books from the schools, okay, are really good, okay, because those are provided by the schools. They summarize all the topics that you studied on the big books, okay, all the 30 hours that you did on each course. They summarize them, and they a lot of times will put bold on the vocabulary within the summaries. A lot of them have vocabulary, others do not, and they have practice questions. So licensing regulations, which of the following best defines a broker? Who is a broker? How is it defined? A Texas resident who performed brokerage activities for compensation. B, a licensee who sells his or her own property. C, a person who performs brokerage activities for others for compensation. Or D, a residential licensee who manages salespeople. Ah, you knew this one? Oh, yes. So far, I've got an answer C. Yes, very good. The answer, it is C. A person who performed brokerage activities for others for compensation. Okay, why does it say brokerage? Because it's the broker, right, who owns all the contracts and all the listings and all the all the contracts and all the listings, even though the associate is the one that actually is direct with the client. So, on A, it said a Texas rep who performed brokerage activities for compensation. Well, no, it has to say performs brokerage activities for others for compensation. That is a broker. Okay, you could be a broker in another state and you'll be getting a referral payment. You referred a client to a realtor or a broker here in Texas. You'll get paid a referral fee. It could vary from, whatever is negotiated, but it's very common, 20%, 25%, or 30%. Why not A? Because it says a Texas resident. Okay, you don't have to be a Texas resident, okay, to have a Texas license. Plus, it also says performs brokerage activities for compensations. Or are they brokerage activities for themselves, for their realtors, or for whom? It's got to be brokerage activities for others for compensation. They could be doing brokerage activities for themselves, but it's brokerage activities for others. That's why we are licensed, because we are doing an activity representing somebody in exchange for compensation. So we are representing someone. So C and D, a residential licensee who manages salespeople. No, residential licensees do not manage salespeople. Brokers do. Okay. In order to manage salespeople, which is a sales agent, you must be a broker. You didn't read slow enough. Okay. Did I type the answer here? Yes. Okay. So it was 12.1C, a person who performs brokerage activities. Okay. So A says a Texas resident. Okay. So is that Texas resident? Oh, another thing. Is that Texas resident licensed? Who knows? Okay. And then, yes, C also doesn't say, that they're licensed. However, it doesn't have to be a Texas resident. And the key words are performs brokerage activities for others. Okay. For others, for compensation. They could be doing brokerage activities for themselves and get compensation, but that's not what we do. We as realtors and brokers, we are doing activities. We're representing others for compensation. All right. Very good. And before we can manage other salespeople, we need to be a broker. And how many years do we have to be a realtor before we can take courses to become a broker? And not only that, well, minimum of 4 years. And you also have to have a certain number of points of different types of real estate transactions that you have done. Residential, commercial, multifamily, unimproved, land, agriculture, industrial, so leases. So we have to be able to have experience of doing all the above types of transactions in order to take our courses. I mean, we don't have to have them to take the courses. We can take the courses and make sure we satisfy all the other requirements within 4 years, right? So after you've been a licensee for 4 years, then you can work towards becoming a broker. I'll tell you what, a lot of brokers are broke. Anyway, that's what a lot of other realtors say, and a lot of brokerages say, because it is a lot of responsibility and a high cost. Number 2, Wow. So 2020 credit repair solutions. So they're someone that who will be able to do credit repair for their clients, right? Just make sure you got to disclose that. Number 2, which of the following best defines a designated broker? Okay. A, an active Texas broker designated by a licensed entity, business entity to act on its behalf. B, a non-officer of a licensed corporation named to conduct real estate activities on its behalf. C, a dual agent in a brokerage. C, a licensee who has successfully passed his or her required realtor designation curriculum. All right. So far, we've got an A. Come on, type your answer in the chatty chat. Okay, DB Fitness, Lisbeth, A. So yes, the answer is going once, going twice, gone. The answer is A, an active Texas broker designated by a licensed business entity to act on its behalf. Like a major brokerage, a huge brokerage, okay, a franchise, they will have designated brokers, okay, the supervising broker, and then they'll have managing brokers. Because when you have a large organization, one broker can't supervise all its realtors. Okay, so they will have other managing brokers. And they're not literally like supervising over your shoulder, that type of thing. However, they're there for when we have questions, need advice, and have to resolve issues within clients. Or they can talk to other brokers for us, because some brokers don't want a realtor calling them to resolve issues. They want it resolved broker to broker. So small boutique companies may have only one broker, and the broker is the owner. Some others, you could be a realtor and have a brokerage with a designated broker so that you don't have to be licensed as a broker. My sponsor was like that. When he had his own brokerage, his mom was the broker. She was the designated broker. So he owned the brokerage. However, he was not a broker. So you have a designated broker. Okay, and I think you all got it right. Yes. Number 3, which of the following parties does have to have a license to operate legally? A, so which of the following parties have to have a license to operate? A person who shows their licensed brother's listing to neighbors in the immediate neighborhood. B, MLS services who provide listing services but do not get paid for resulting transactions. C, a family member who sells a house she just inherited from her father. Or D, an employee of Burger King who assists in the purchase of a site for his company. So which of the parties has to have a license to operate legally? All right, Tamar, that's okay. Okay, so far I have A. And the answer is D. Nah, I'm just kidding. The answer is A. All right. A person who shows his licensed brother's listings, okay? Licensed brother's listings. So they're showing that property to neighbors in the immediate neighborhood. Okay. So that person has to have a license to operate legally. Awesome. Y'all did great. Oh, Lisbeth, you sent me a surprised face, and Jaylene, let's see. Surprise face. So what was that? What did you answer? Oh, well, you answered A. And then Jaylene's laughing face. So I'm not sure. I forgot already what I talked about. Oh, yeah, an employee of Burger King who assists in the purchase of a site for their company. They're an employee of Burger King, so they don't need a license, okay? That's different. Oh, I don't need to enlarge. Y'all got that? I like that cracking up face. That's me, always laughing. Well, not always, right? Chill. When you said D, oh, yeah. Yeah, that was funny, right? So a Burger King employee, okay, does not have to have a license. So like if you were to happen to work with a developer and you're their employee, okay, or a builder, you don't have to have a license in order to show their properties because you are being paid as an employee. You're representing the owner, okay, not representing a client. Y'all got that? Yes, got it. All right. All of the following are exempt from real estate licensure except one. Okay, so all of them are correct except for one. Which one is not exempt from having a real estate license? A Texas attorney. B, a party acting under the auspices of the court. C, an on-site manager of an apartment complex. Or D, a city mayor who operates a rental agency. Okay, Tamar, are you answering? No, you all answering the prior question. Okay, help us out by when you participate, type the question number and the answer so that we know which one. Okay, so you said both. So number 4. No, it is not. Well, 12.3 was A, right? Yes. Oh, I didn't type the answer up there. I'm talking to myself. So the answer, oh, wow. Yes, all of you are doing great. So I typed the answer for 3, so don't get confused there. It's 12.3A. I hadn't typed it on Facebook. So when I type it on Facebook, it shows up on here on the private Facebook group. So yes, the answer here is D, right? If the city mayor operates a rental agency, right? Because they are renting properties that belong to other individuals. So they're representing their client, their principal, the owners of it. I mean, the properties could all be theirs, the city mayor, but it says, a rental agency. So more than likely, they're going to be representing other individuals, other property owners, okay? So 12.4D. Very good. All right, so Tamar now says, now I understand the option period. Okay, awesome. Yeah, the option period, it's unilateral. Only the buyer is performing and the seller is waiting until the buyer makes a decision after all the due diligence and inspections and gets the reports, making sure they make a decision. I like to do it 24 hours prior to the deadline because sometimes messages don't get across and it has to be notified. The seller has to be notified before the deadline at 5 p.m., right? Right. So that is a unilateral contract. It's one-sided. Only one person is performing. When both of them are performing after the option period, then it goes back to bilateral. Two-way, right? All right. And so nobody answered A, right? No. Everybody answered D. Yes, very good. Okay, number 5. William has been named designated broker for the partnership he works with. For this to be acceptable, William must what? A, Be an active licensed sales agent or broker. B, be a general partner of the firm. C, be an employee of the partnership. Or D, must have been affiliated with the firm for a minimum period of 12 months. So the first one is, right, actively licensed agent, sales agent, or broker. So this is with the partnership that he works with. Yes, very good. The answer is B. Be a general partner of the firm. Awesome. Be a general partner of the firm. And you know what? General is a very broad partner. He's got broad, that William's got broad responsibilities, right? And he works with. So William has been designated broker for the partnership he works with. So it's acceptable when William is a general partner of the firm. All right, oh, wow, it doesn't have a number, but it's number 6, 12.6. If an applicant fails to prove to the commission he or she blank, he or she can be denied a license. A, is registered to vote. B, has a net worth over $25,000. C, is honest or trustworthy. Or D, has an insured car and driver's license. Okay, Tamar, awesome. You are all understanding. And when you don't, you know what to do, right? Ask. Because I tell you what, in this business of real estate, you'll have to ask lots of questions in order to be able to help our clients and know exactly what they want. And listen, listen, listen. Awesome. Wow. Y'all are doing great on that one. Yes. C is honest, be honest and trustworthy. Very good. All right, number 7. Oh, man. Okay, it's going to be small. Well, not real small. Awesome. Wow, great. Lots of participation. I love it. Oh, Tamar, you all right answering this one? Tamar, remember, type the question number because I don't know which one. We don't know which one you're responding to, Tamar. Type the question number, please. Number 7, to obtain a Texas real estate sales agent license, applicants must complete what? 60 hours of real estate principles and 120 of finance, law, contract forms, and agency. B, 90 hours of real estate principles and 90 hours of law, finance, and agency. C, 120 hours of pre-licensure education and 60 hours of post-license education during the 2-year license period. Or D, 90 hours of pre-licensure education and 90 hours of post-license education during the 2-year initial license period. It is not D. Be very careful. Know the 6 courses that you're taking. Each one is 30 hours. And yes, the answer is A, right? You're taking 60 hours of real estate principles, right? Principles 1, principles 2, and then 30 hours each of finance, law, contract forms, and agency. That's 4 classes times 30 hours. That's 120 hours. Very good. Very good. Sehr gut. That's in German. Sehr gut. I had learned German because I traveled a lot to Germany in my second career. My second job. Okay. This is not my job. This is my business. Okay. This is going to be your business. You're the boss of you. Okay. Very good. Hey, I got to add a little humor to this, right? Because, you know, learning this stuff can be boring. We don't get into it. All right. Number 8. Which of the following is true regarding license requirements? Okay, wait a minute. I got to go back. So what is interesting, Mr. 2020 Credit Repair Solutions? Actually, what's your name? What is interesting? All right, number 8. Which of the following is true regarding license requirements? A, non-resident license applicants must meet special out-of-state education requirements in Texas law. B, non-licensed applicants must agree to forfeit any non-Texas real estate license. C, successful license applicants will be issued an active license, which is sent to the applicant's sponsoring broker. Or D, which of the following is true regarding the education requirement for the, I'm reading number 9. D, applicants must have met all requirements to receive an inactive license. Oh, yeah, he says Brooklyn Daddy. Yeah, I thought that was pretty cool. Brooklyn Daddy. He's got 6 kids. And then German language. Yeah, I learned that. Sehr gut. Alles gut. All is good. So D, wie geht's? Right? Welcome. Wie geht's? No, how are you? The answer is D. Very good. Sehr good. Muy bien. Hablo español también. También hablo español. Awesome. Very good. Very good, y'all. All right. Number 9. Every time I say number 9, it reminds me that like there was a song or a movie. I can't think of which one it was. Maybe y'all can help me. All right, number 9. Which of the following is true regarding the education requirements for the broker's license? True regarding education requirements for a broker's license, not a salesperson. Okay. A, applicants must complete 630 hours of post-secondary education. B, applicants must complete 900 hours of post-secondary education, including 630 hours of core real estate courses of their approved equivalent or their approved equivalent. C, applicants with a bachelor's degree or more are deemed exempt from the core 270-hour requirement. Or D, applicants must complete 270 hours of post-secondary education. Very careful on here. All right. So Naz says, gotta speak learn Spanish. It may be a need and may not be a need. It depends. Is it a need for you or because of clients? Yes, the answer is B. Applicants must complete 900 hours of post-secondary education, including 630 hours of core real estate courses or their approved equivalent, which could be a bachelor's degree. Now there are college degrees, okay, for real estate. But like my engineering degree was approved for the 630 hours, and I was taking the 270 when I got my license here in Texas in end of 2013. But I never finished. I'm like, well, I was a broker in Oregon. I might as well get my brokerage here, even though I don't necessarily want to represent, I don't want to supervise anybody. So no, the answer is B, Tamar. It is 900 hours. Okay. You can be exempt from the 630 by being approved by your bachelor's degree. However, you still have to take 270 hours to complete 900 hours. So it's a lot of education. So mostly individuals who have a bachelor's degree can avoid, the 630 hours when they're approved by TREC. So it helps to have a bachelor's degree. Otherwise, you are taking 900 hours. So Lisbeth knows Spanish. Yes. Lisbeth Gittin de Fernandez. Gittins or Gittins? She's from the Rio Grande Valley. That's where I'm from. Rio Grande Valley is South Texas. Okay, there's my 8 o'clock alarm. Unwind. Okay, so we're almost unwinding here. All right, number 10. Oh. Let's see here. Does 10 off? No, it doesn't come out. Okay, number 10. Yes, ma'am. Gittins. Okay. All right. No. Oh, let's see. Cindy says Mambo number 5 song. Lots of laugh. Oh, it wasn't number 9. It's Mambo number 5. Okay. Thanks for that. Thank you for that. Number 10. Trek, I love when you all interact and respond and comment back to me. We've got to make this lively, right? We're learning. And if it's boring, it's hard to really get it. Okay. It gets really dull. And that's why a lot of researchers say studying with music or classical music helps you learn and relax. So many love to do it. I can study to different types of music. Okay. Well, except for dancing music, I guess. Number 10, Trek may waive a broker's education and experience requirement if A, the applicant earned a master's degree in real estate. B, the applicant was a licensed attorney for 2 of the prior 4 years. C, the applicant was a broker for the prior 2 years, completed their continuing education CE requirement, and was active for 2 years of the prior 4 years. D, the applicant was active sales agent for 4 of the previous 5 years preceding the application. So Trek may waive a broker's education and experience requirement if, yes, the answer is C. Very good. If the applicant was a broker for the prior 2 years, 2 years prior to now, completed their continuing education, right, which we have to do every 2 years. And nowadays it's Legal Update 1 and Legal Update 2 plus 10 more hours elective, and was active for 2 of the prior 4 years. So yes, very good. 1210C. Not kicking butt. Well, you could be kicking manure too, right? If you had shit kickers. Boots. I love damn boots. I got lots of them. All right, come on. All right, number 11. Which of the following statements is true regarding license renewals? A, licensees must be renewed every 3 years. B, all licenses expire on December 31st of even years. Or D, Trek distributes a notice to renew 3 months prior to expiration. Or D, timely application must be received no later than 30 days of following expiration. Ooh. Ha ha. Yep. Ha ha. All right. So which one is true regarding license renewals? Me too. Okay, you love them boots. Oh, I didn't give you enough time to answer. Yes, the answer is C. Trek distributes a notice to renew 3 months prior to expiration. So that way, you better be looking at your email regularly, right? Or at least prior to your expiration coming. And hopefully when all of you get your licenses, remember, you've got to do 90 hours, within your first 2 years of MCE, mandatory continuing mandatory apprentice. Oh, what am I trying to do here? So it's mandatory continuing education, right? So you're kind of an apprentice. So you take 90 hours plus legal update 1 and 2. So what I did is I ended up taking a certification. You could do GRE, and it's 3 classes of 30 hours each. And there's other certifications, like I took Certified International Property Specialist. It was 3 courses, 30 hours each. So I did those, got them all out of the way, and got a certification. Have I used it? Not really, but I have dealt with a couple of Mexican nationals, maybe a few more, even though I live close to the border. CCC. Yeah, oui, monsieur. That's from Medea. Oh, 12. All right, number 12. A licensee misses the deadline for license renewal. In this case, okay, so licensee misses the deadline for license renewal. In this case, the licensee can do what? A, must retake the license examination and pay late fees. B, must pay a deferral fee and complete any CE requirements within 60 days, continuing education, CE. C, must go inactive for a minimum of 90 days. Or D, must resubmit an initial licensure application, including background checks. By the way, this is not the first time you see these questions, because I use this book and another book, okay, that I'm allowed to use. And it's like when I say, repeat the questions over and over until you ace them, until you get 100. Okay. You're mostly recommended to at least get an 80 on prep exams. I say, keep doing them, repeat them until you get a 100. The more you see them, the more you repeat them, the more you'll understand them, pick up those little keywords and get them correct. Like what do they say? Repetition, repetition, repetition maybe makes you perfect. However, you don't need to be perfect. Perfection can cause a lot of issues. I know. Okay. Personally. Okay, number 13. So, so it was must pay a deferral fee, like $200, and complete any CE requirements within 60 days, plus pay the renewal fee and take the 18 credit hours. Okay. So the license may have expired. However, they were allowed an additional 60 days to take the courses, this continuing education. Then C, no, it's not C, nor D. The answer is B, okay? Must pay a deferral fee. So a licensee misses the deadline for renewal. As long as they paid prior to the expiration date, okay, then TREC will approve an extension for 60 days, or it's called a deferral. And we have an additional 60 days to finish that continuing education. So we pay the $200 deferral fee plus the renewal fee. And of course, then we take our courses and send the certificates in, and make sure we do it at least 5 days prior to the expiration of the 60 days, right? Because they need time to review it and get the documents. And if you do send them right at the end, you better be on the phone calling. Make sure they get it. All right, number 13. Which of the following is true regarding the renewal of an expired license? Okay, so I just kind of explained that. A, renewing applicants do not lose active status if they properly renew within 90 days. B, with a proper application, late renewers filing within 60 days of expiration will not lose active status is sponsored throughout period between expiration and new license issuance. C, expired licensees automatically become inactive. Or D, the license period for the renewed license begins the day the late renewal application was received. So So which is true regarding renewal of an expired license? I made a comment that a license can be expired. However, when we pay the fee, no, it is not C. They are not automatically inactive. If we pay the $200 deferral fee, then the license stays active for an additional 60 days as long as we still have a sponsor throughout that period between expiration and new license issuance. So we pay the deferral fee prior to the expiration date. So yes, the license expired. However, we've been given 60 days. And so the license stays active. We still keep a sponsor and keep practicing real estate. And we finish our continuing education 18 hours and send the certificates with time enough before the deadline of the 60 days. Oh, okay, you got it. So hold on, let me type the answer. 1213B. And if y'all see me type the wrong answer, let me know, because sometimes I think one thing and I type a different one. So a question here. What if you are in between a real estate deal? Would they hold your commission? No, well, you're still active. Okay. So the deal continues going on. You still have your broker sponsor. Okay. So no, once your license becomes inactive, you don't get paid commission if you're in the middle of a transaction. That goes to the broker and they'll assign somebody else. However, it expired. However, you've been granted 60 days by paying that deferral fee. Therefore, you continue to practice real estate as usual, as long as you're under a sponsor. Okay, so 1213B. Got it? Number 14. Licenses can become inactive for many reasons, 3 of which are listed below. Which statement does not trigger an inactive license? Okay, so which one does not trigger it to go inactive? 14A, the state changes the education requirements for licensees. B, the sponsoring broker moves to a different state. C, the brokerage goes bankrupt. Or D, the licensee applies for inactive status. So which statement does not trigger an inactive license? That means you continue to have an active license. Type your answer in the chatty chat. Put 13. Gosh, it's 12. All right. Yes, the answer is A. The state changes the education requirement for licensees. Okay, so if the state makes that change, then they're going to allow time to meet those requirements, probably until the next renewal date. So like we used to have 15 hours of education. So our license doesn't go inactive when they decided to increase it to 18 and then require we take legal update 1 and legal update 2. When our renewal date comes up, then we meet those new requirements. I thought I had typed the answer. 1214A. Okay, so 1213 was B and 1214 is A. All right. Y'all did awesome. Good. All right. Number 15. Very good, y'all. Which of the following are causes for the deactivation of a business entity license? A, the business obtains E&O insurance. B, the entity elects to deactivate. C, the entity fails to complete a transaction in a 12-month period. Or D, the designated broker is promoted to president of the corporation. So which one causes the deactivation license to be, deactivation of a business entity license? Oh, and you're going to see an answer come up, and that's for the prior question. So type your answer in the chatty chat. There are many, many, many of you on here. So this is an awesome class, an awesome turnout. Many of you must be needing to pass your Texas state exam, and some also the national. But I know there's a few of you that need to take the state again. So for all of you, those of you that are brand new today, hey, thank you for joining us. It's awesome having you here. And I hope that you find it beneficial and useful and helps you along to prepare for your exam and pass. Okay, the answer is, only Lisbeth has answered. Oh no, there's a few more. B. Yes, the answer is B. The entity elects to deactivate, right? The fact that they don't have any closing transactions, that doesn't have an automatic, within 12 months, that is not an automatic deactivation. Or you can have an entity and not be practicing real estate. Yes, awesome. Thank you, Cindy. All right, I lost track of how many questions we've done, but you know what? We've really gone over. It's already 8:16. So we are going to end our Texas State questions at that point, unless you want me to do another few, because we started with test number 11-1. So we've done quite a few questions. So if anybody is taking the test, I think somebody is taking it Sunday and they need to pass the Texas State. So if you'd like me to do a few more, I will. This will be a long class, but I admire that you are here still attending and listening and learning. We already did national, Melanie's. So the beginning of class was national. All right, if nobody says, you want me to do a few more questions, we will call it a night. Okay, we can end the class. You have all night. Oh my gosh, where are you located? What's your name, Mr. 2020 Credit Repair Solutions? 15 is, what does that mean? Okay. I'm good with another few if anyone else is. Oh, okay. All right. I have a test on the 13th. Oh, okay. That's coming up. Let's do it. All right. So you're in Texas, but what is your name? Okay, let's do some more. Tiba Cummings. Okay. Hey, Tiba. Welcome, welcome. This is your first time, I believe. Okay. No, we do. Okay, got it. Here we go. Thank you so much. First time here. Will join and be more active as I am just starting my studying. Awesome, Nas. I'm so proud of you for being here, and thank you for the compliments. All right, number 16. Oh, I guess I need to share it, right? Which of the following is true regarding the maintenance of one's license status? A, deactivating brokers must give sponsored sales agents a 30-day advance notice from the date of application. B, a sponsoring broker, can't see it all, has to notify TREC of a sales agent firing within 1 week of the occurrence. C, to reactivate a broker's license, the broker must satisfy all CE requirements and take 3 hours of ethics. Or D, to reactivate a sales agent license, licensees must complete a 3-hour legal update course. So I just mentioned about that legal update, right? And how many hours it was. So do not select D. Okay. I mean, you can, but it's going to be wrong. Oh my gosh. Type your answer in the chatty chat. Come on, come on. It is not C. I'm sorry, Lisbeth. So the answer is actually A. Deactivating brokers must give sponsored sales agents a 30-day advance notice from the date of the application to deactivate. Okay, they need to allow their sponsored realtors enough time to find another broker and transition, elsewhere. Because it can be really challenging having to change a broker if you're very, very comfortable there. However, it's a way to expand, okay? Stretch the envelope and get comfortable with the uncomfortable. Okay, so that was the end of, what was that? Regulations section. Oh, I can just look at the... Yes, so now we go to standards of conduct in brokerage practice. Standards of conduct in brokerage practice. Yeah, I think what we just covered, okay, was licensing regulations, right? All right. So number 13.1. Licensees must conspicuously display Form 1-1, a consumer disclosure form. Its central message is A, licensees should abide by the rule, caveat emptor, or let the buyers beware. B, licensees do not necessarily represent the party who compensates them. C, TREC maintains a recovery fund that may be used to satisfy judgments against licensees who have violated the law. Or D, licensees are bound by any duty to maintain confidentiality in their dealings with customers and clients. Okay, well, you all thinking of that? It says fear equals false expectations appearing real. That is correct, Tamar. Very good. Thank you for sharing that. And you all look at that. False expectations appearing real. We don't know what the future is bringing yet. So that's what fear creates. Fear of the unknown, of the future. So don't fear it, just do it. All right, number 1. Ooh, number 1 is not A. Number 1 is C. TREC maintains the recovery fund that may be used to satisfy judgments against licensees who have violated the law. That's what's in the Form 1-1, a consumer disclosure, letting the consumer know that they can complain against a licensee that misrepresented them or did something that impacted them negatively. So 13.1. C. Very good. So Jaylene, a licensee should abide by the rule, caveat emptor, or let the buyer beware. No. Okay. We do disclose and advise, but that's not what Form 1-1, this consumer disclosure form has. So it is, whoops, I knew that one. Yeah, you did. I'm sure you did, Cindy. Okay, number 2. Unbeknownst to a buyer, an intermediary informs a seller that the buyer will pay a premium price for the seller's property. Is this an acceptable disclosure? So unbeknownst to a buyer. So when does a broker become an intermediary? So the intermediary here is the broker, right? Because only brokers are intermediary. So unbeknownst to the buyer, buyer did not know, buyer was not aware, buyer beware. Buyer was not aware. An intermediary informs a seller. So the broker represents a seller that the buyer will pay a premium price for the seller's property. Is this an acceptable disclosure? A, yes, since the intermediary represents the seller, he is acting in the seller's best interest. B, yes, since it is common knowledge that the buyer is on a very tight deadline to move in. C, no, since the intermediary did not receive the buyer's authorization to make such a disclosure. Or D, no, since the disclosure violates the agent's fiduciary duty to the buyer. So what is this, number 2? No, it is not D. So an intermediary is the broker. Okay. C says, this is not acceptable. That part is true. The first part, no, is true. However, but not since the disclosure violates the agent's fiduciary. It's not the agent's fiduciary duty that's violated. It is the broker. No, since the intermediary did not receive the buyer's authorization to make such a disclosure, because remember, the broker mediates the buyer and the seller, cannot give advice or direction or negotiate or inform. Okay, they're there to mediate between the buyer and the seller with their appropriate associate appointed realtor, the agent for the seller, agent for the buyer. Okay, so the correct answer is C. No, since the intermediary did not receive the buyer's authorization. So they have signed an intermediary. However, that confidentiality has to stay there, and the intermediary cannot do that. We're there as a mediator. The buyer agent, if the buyer gave the buyer agent the authorization in writing to do so, well, yeah, but no, we're there to get the lowest and best price for a property for our buyer, right? With the specifications, the requirements that they really need, not just want. There's a difference between need and want. Our job is to keep them closed and focused and narrow on what their needs are based on their pre-approval letter, what they can afford, and how it accommodates, their needs of family, single person, or whatever it may be, pets. Yet an intermediary nor the buyer agent can disclose, okay, that the buyer will pay a premium price. If a buyer wouldn't be volunteering to do that, okay? If they do, it's because they really dang want that house. And that can happen in a multiple offer situation. However, it's going to be put in writing. Okay, number 3. A licensee who is charged with felony fraud pleads no contest, and all charges are dismissed. In this case, the licensee A may have his or her license suspended or revoked. B must notify the real estate commission of the guilty plea. C is exempt from any commission notification since there was no guilty plea. Or D has done nothing wrong. Okay, so the licensee was charged with felony fraud, and pleads no contest. Okay, so and all charges were dismissed. So in this case, the licensee can be what? No, it is not B. Okay, they will notify TREC, okay? However, what is it that could happen? Nope, it is not C. The answer is A. Their license may be suspended or revoked. Okay, that will be evaluated by TREC, Texas Real Estate Commission, right? Maybe having a, what do you call it? A review committee meeting, okay? And so they will notify the real estate commission of the guilty plea, okay? Because on our application, it does mention on there, and TREC will still issue licenses, okay, if there's a felony, but they have to evaluate everything, ask for a lot of documentation and explanation and such. And so they may have their license suspended or revoked. Doesn't mean they will. Okay. All charges were dismissed. Okay. However, why? Was the felony fraud very serious? Okay. So that will be up to the review committee and TREC, okay, to investigate. So they did do something wrong. They were charged with felony. Well, according to that, okay. However, they pleaded no contest, and then their charges were dismissed. So why were the charges dismissed? Not just because they pleaded no contendere, okay, no contest, or not guilty. All right, so may have their license exempt, and they're not exempt from any commission notification since there was no guilty plea. Must notify the real estate commission of the guilty plea. Well, they were charged with a felony, but they said no contest. They didn't plead guilty, right? So they did nothing wrong. So B and C mentioned that the B says that he plead guilty. The C says exempt from any commission notification since there was a no guilty plea, but they were charged with felony. Okay, so that is reported to TREC. Let's see what the book says. Licensees must notify TREC of any felony proceedings where the license pleaded guilty or no lo contendere, meaning no contest. Okay, so the B says must notify TREC of the guilty plea. Well, it didn't plead guilty, but they still have to notify TREC of the no lo contendere, no contest. Okay, because they were charged with a felony. Let's see if that'll work. No, that's not going to work. Okay, this is going to turn out small. All right, number 4. A licensee opts to use a custom designed form to transact a residential sale. The contract used was a bona fide sales agreement used extensively prior to the existence of TREC promulgated forms. In this case, the licensee is what? A, faces legal exposure for the unauthorized practice of law. B, could have her license suspended or revoked. C, may supplant a promulgated form with a previously used contract with impunity. Or D, has not committed any violation of license law. So remember, we need to keep up with current promulgated documents. So what would happen by using a extensive prior to the existence of TREC promulgated forms? Nobody answering. The answer here is B. Could have her license suspended or revoked. He or she could have their license suspended or revoked. Okay, number 5. Which of the following is a licensed law? Which of the following is a licensed law violation? A, failing to retain trust funds records for the required 6 years. B, advertising listings without an advertising license. C, failing to recommend that a buyer obtain an inspection or on a transaction. Or D, failing to disclose a previous licensed tenancy from another state on the license application. Type your answer on the chat. So far we have a D. All right. Anybody else? Going once? Going twice? Gone. The answer is D. Failing to disclose a previous license tenancy from another state on the license application. So when we complete our application, TREC does ask whether we're licensed in another state. Okay, so we are asked that. Okay, you all, we did 5 more questions. Any questions on those? We're going to call it a night, okay? We've been on here a fun 2 hours and 36 minutes. Wow. I think this breaks the record of the longest live webinar or class, all because of you, okay? And I leave my Monday and Wednesday nights, okay, for this. And I keep having fun and learning also from it. Okay. All right. You're very welcome. Thank you. Oh, shoot. I forgot your name. I remember you typed it. So remember, you all, to practice, lots of questions and your vocabulary. Okay. Words, vocabulary. You're learning a new language. Oh, T. Yes, thank you. And so practice those questions over and over until you get 100, even if it's the same questions. Okay, you get used to them and you recognize them much quicker. You read through them much quicker. And if something isn't working, try something different. Talk to other students, okay? Other individuals that just passed. Collaborate with them. And give yourself the time, work on your attitude, your mindset. Okay. Keep a positive mindset. Okay. Don't punish yourself. Don't talk negative things. The mind believes what it hears. Okay. So if you speak positive things, it goes back to the mind. And that's what we want to do. Stay positive, encouraging, get some outside support. Okay. From family, friends, other realtors, other students, and keep up. Okay. If you're not passing, it's because of your study methods. You're not studying regularly. Your mindset is negative. You're feeling down on yourself. You're doubtful. Okay. You're insecure, low self-esteem. Got to change all that. Got to fix the mindset in order to be able to focus to pass an exam. Remember, we do not fail. We realize we need to prepare more, study more to pass. I always use a Thomas Edison. How many times did he test to try to make the light bulb, invent the light bulb? 1,000 times. And he says, oh, I didn't fail. That way didn't work. So I'll do it again. Okay. So find a different way. Don't keep repeating the same things. If you don't pass, try something different. So Cindy, you're very welcome. We'll see you Saturday morning, and good night. And so T was from Credit Repair. Thank you for joining us tonight. Naz, Tamar, all of you were new, and there were some others. I appreciate all of you. And if you haven't been to my YouTube channel, hey, go over there, tap that subscribe button. Okay. Tap that like button, send me some love. All right. So I can continue doing this, and click that little bell so you're the first to get notified every time I go live. And there are books down in the descriptions that you can buy from Amazon, okay, that I use on here, and other books that you might find on there. Use my link, Amazon. I am affiliate for Amazon, so I will get paid a fee, an affiliation fee for you all using my affiliate link. And actually, it'll give me credit for anything you buy if you go to my Amazon link. Okay, until next time, catch y'all later. This is Wild Lily Handy coming to you from San Antonio, Texas with YouTube Agent Prep. Have a good night.